Good morning, everybody. How is your day going? I hope you're having a beautiful day. You're welcome to Legal Clues on Emirate Radio. Of course, this is the first program, the first episode of Legal Clues we are having here in 2025. I want to wish you all a happy 2025. My prayer for you all is that you have a fulfilling, rewarding, blissful 2025. May all our aspirations, our dreams, and our prayers before God be fulfilled and met. I pray you all have a wonderful year, a year where you break through and you break even. The Lord bless you all in this wonderful year. My name is Damilola Obadimeji, your host on this program. You know, on Legal Clues, we bring you tips, legal tips that helps you to make informed legal decisions. We give you tips that will help you to be able to run away from crime, to be able to help you to know your rights and your obligations as citizens of this country. On today's episode of Legal Clues, we'll be discussing contract. Contract, I am so sure that contract is, applicable to virtually everybody. Everyone, one person or the other, will have engaged in contract before or intend to engage in contract. So today we want to talk about contract. What is contract? What are the essentials of a valid contract? We'll talk about how you can bring an action against breach of contract, the limitation period you have to bring an action against breach of contract, and so on and so forth. Just those vital things that you need to know about contracts and the things surrounding it. Now, in a layman's language, what is a contract? A contract is an agreement between two parties that creates an obligation to perform or not to perform a particular duty. Now, for a contract to be created, there must be at least two parties. You cannot do a contract with yourself as a party, one party alone. No. So it must be an agreement between two parties or two or more parties for a duty to be performed. And of course, in creating a contract, this agreement specifies your actions and the things you should not do. A contract agreement will specify those things that you will do and the things that you should not do, which we usually refer to as the terms of the contract. So, of course, in a contract, for it to be binding, the parties have to have terms of agreement that will specify the consequences if the terms are violated. And not all contracts are written. There is, of course, sometimes oral agreement, but it's always advisable. Like I used to say here, nothing is obligated here, but we used to advise you to put your agreements in writing. It's always better to look for a legal practitioner to help you reduce your agreements, your contract agreement and terms into writing. So there are a lot of things that must be present before you can say that you have a valid contract. Like I said earlier, a contract has to be an agreement between two or more parties that will make it to formalize a transaction between them. And of course, contract can be used in different kinds of business dealings, ranging from maybe real estate, buying of property, to trading in services and goods, to employment arrangement, and others. So contract can exist in different spheres of life. And contracts are essential for making sure that all parties know their rights and their responsibilities before they enter into any kind of agreement. So in other words, you need to reduce these things into writing so that each party will know what they are supposed to do, their rights, their obligation, the terms that when violated, they can, there will be consequences for it. And contract that you voluntarily enter into is binding on you. You are binded by a contract that you voluntarily enter into and you sign. So you should know that once you enter into a contract, you put it into writing, you sign it, you agree, you are binded by it. You cannot on your own terms without, the consent of the other withdraw from it. You are binded by it, by the terms of the agreement that you enter into freely and without duress, of course. So where there is a valid contract and agreement, the parties must be held bound by the agreement and by all the terms and conditions that there should be no room for departure from what you have stated in your agreement. You cannot just wake up one morning and say, I'm not pulling through. An agreement that you have both signed, you have agreed on, you are binded by whatever it is that you have agreed on. Now, for you to say that a contract is valid, and for you to say that a contract exists between you and another person or other people, there are some essentials that must be present before you can have a valid contract. The first one I have is offer. Of course, we know that there cannot be a contract without an offer. An offer is what kicks off that contract. A party needs to make an offer to the other person. For example, okay, I come to you, I want to sell my building for 20 million naira. That is an offer. I'm offering it to whoever can pay 20 million naira. That is an offer. Now, so for there to be a valid contract, there must be something kicking it off, something starting it. The offer you are proposing, that is what will start a contract at all. For there to be a valid contract, there must first be an offer. And of course, an offer might either be accepted or not. So an offer, when it's been made, the receiving party may try to probably accept it or to reject it. Or sometimes they may make a counter offer. That's where negotiations comes in. Like, I want to sell for 20 million. Oh, I don't have 20 million. Can I pay 15, So, or if it's accepted, okay, I will pay the 20 million. So an offer can either be rejected, be accepted, or a counter offer might come into play once you have offered what you are willing to bring to the table. Now, once there's an offer, there is an acceptance. For there to be a valid contract, the offer you have offered out must be accepted by the receiving party. That's the other party now. So once an offer has been made, the other party, we have to accept it in order for that contract to be valid. What's the point of making an offer at all if nobody accepts it? You understand? So an offer must be accepted in order to crystallize into a contract. And you must consider a contract to be accepted once it is, like I said, it's advisable to put into writing and it's signed. Once you put into writing and it's signed by both parties, of course, the offer has been made, acceptance has also occurred, and you have reduced it into writing. So for there to be a valid contract, there must be offer, there must be acceptance. Please note also that acceptance can be implied and can also be expressed. Okay, if I say, okay, I want to paint my house and I'm willing to pay 5,000 naira. You have not told me that you can do it, but you go ahead. The paint I brought, you started painting. It's implied that you have accepted. So acceptance can be implied and can also be expressed. But bear in mind that for a valid contract to exist, there must be what we call offer, there must be acceptance. And the third thing that must be present before you can say you have a valid contract is consideration. Consideration is the whole reason for a contract. It's the value that each party agrees to exchange to make the contract valid. Most times, usually the amount, okay, I want to sell my house for 20 million. The 20 million now is a consideration. Okay, I want to sell my house in exchange for a service that you're going to render to me. That service is the consideration. So the consideration is that value. It can be monetary and sometimes might not be monetary. Might be services, might be goods, can be monetary as well. Is that value that each party agrees to exchange to make a valid contract. That is consideration. Like I said, can be in form of money, in form of goods, in form of services, or other form of legal tender that both parties agree upon. The element is essential because it sets out what each party gets if they fulfill their end of the bargain. It's the very essence of a valid contract. For example, if an employer-employee relationship now and you want to work, nobody's willing to work for free. Of course, the employer is willing to offer you this particular amount, you accept it. That amount is the consideration. The services you are rendering also is the consideration. We've talked about offer, we've talked about acceptance, and we have talked about consideration. The fourth essential that must be present before you can say you have a valid contract is capacity. Capacity, simply put, is the party's ability to comply to their end of the contract. Their ability, you must be capable under the law. Firstly, capable to understand the obligations imposed upon you on the contract, capable to be able to execute those obligations. There are a few examples that can make somebody lack capacity. For example, where A party is a minor. In Nigeria, minors cannot enter into contracts. So if you are below the age of 18 years old, you might not be able to have the capacity to contract legally. So it's part of the instance where someone can lack capacity. When you're a minor, you don't have contractual capacity. It's an example of you lacking capacity to enter into a valid contract. Another instance where somebody may lack capacity is if the person's of, if the person is mentally unsound or mentally unstable. You don't expect somebody that is not mentally okay to understand the obligations imposed on him or her in a contract. So you can lack capacity if you're not mentally sound. So mentally unstable person lacks the capacity to enter into a valid contract, a valid legal contract. Also, if you're under the influence of probably alcohol, drugs, at a particular time where the contract was entered into, you lack the capacity to enter into a valid contract. Also, if you entered it under duress, you're forced to do it, there's duress, you lack the capacity. And if, for example, if you don't speak that language and there's no illiterate jurat, you lack the capacity. If you're an illiterate, for example, and there's no, proper understanding of what you're signing or what you're going into, there's no illiterate jurat in your agreement that explains better to that person before he appends his signature, the person might lack the capacity to enter into a legal contract. So there must also be capacity as an important essential element of a valid contract before you can say that contract exists. Another essential of a valid contract is legality. Legality. You must make sure that that contract you're entering into is legal. The activities you want to do in that contract must be legal. There are some instances where we will say that a contract is illegal. For example, if you violate public policy, agreement must be within, the federal, the state, and the local law ordinances. You cannot do an arrangement or a contract that violates public policy and you expect it to stand. It will be deemed to be illegal. If it's made under misleading circumstances too, it might be illegal. And like I said earlier, if it involves illegal activities, if you want to be selling some things that are illegal in Nigeria now or that are not accepted, of course you should know that it's illegal. So there are things that can make your contract illegal, like I mentioned, if you are engaging into illegal activities, if it's entered into in misleading circumstances, if it's going to violate public policy, this can be said to be illegal. So all these essentials must be present before you can say that you have entered into a valid contract. You must have offered, someone else, the other party must have accepted what you offered. There must be consideration. You must have capacity to enter into contract as the parties, and of course that contract must be legal. Those are the essential element that must be present before you can say that yes, of a truth, we have indeed entered into a valid contract. Now, enforceability of contracts. Once you enter into a contract, you are supposed to fulfill your terms of the agreement. You are bounded by what you have entered into willingly, where nobody forced you, where there's no duress. It was legally entered into. You must fulfill your obligation. So it must be enforced. And there are instances whereby it might become difficult or impossible for a party to fulfill its obligation. We call it force majeure. There are some force majeure events that can happen. In layman's language, let me call it act of God. Some things that can occur that will make a contract to be unable to be actualized. It will make a party to a contract unable to fulfill its term. For example, during the COVID-19 period, lockdown period of 2020, a lot of contracts was unable to be fulfilled, which was nobody's fault. It was just an act of God. The virus broke out and everybody had to be indoors. So you cannot hold any party responsible for that. Sometimes some act of God will happen, maybe on a building, for example, and there's a flood or something happened and the building collapses. It is due to no fault of either parties. Act of God. So in this instance, nobody can be held responsible for breaching or not enforcing such contract. So it is to say that where there's no force majeure, no act of God, no event that can be classified as an act of God occurring, then you should know that you must fulfill your obligations. Let me talk about what we call part performance. Part performance is where somebody partially fulfill his obligation. He has not fulfilled it totally, but he has fulfilled it partly. There are instances where someone has fulfilled his obligation partly, and you, on the other hand, the other party now, do not meet his own obligation. The person can be held liable. Let me give you an example. If I want to buy a property now, and the seller already told me, okay, I'm going to sell this property for 20 million, and I said, oh, I don't have 20 million. Let me just pay 15 now. In a month's time, I'll pay 5, the remaining 5 million naira. And the seller agrees. Collected my 15 million naira. Now, a week after collection of that deposit, another person came to meet him and said, I'm ready to buy this property for 30 million naira. Of course, the human tendencies in him will want to be like, 30 million, let me sell to this person. And he will want to return my money. You can't do that. I have partly fulfilled my obligation, though not in whole. I've not paid everything. I've paid some. You cannot say that you are not going to sell to me. You should refund my money. I can bring an action against you for breach of that contract. That is what we call part performance, where I have fulfilled part of my obligations, although not in whole, not everything, but fulfilled part. You should also fulfill your own obligations. That is what part performance is talking about. You cannot benefit from an action you have already, for example, an action you have committed into. You cannot just change your mind overnight. So now, there are some instances whereby you entered into a contract, the other person is not willing to fulfill his obligation. What can you do where there is breach of contract? Where breach of contract exists, you can sue the person for breach of contract. There are so many remedies, a number of remedies available for a party bringing an action against another person for breach of contract. It starts from damages. Where you have suffered some damages due to that breach, it can lead to applying to court through your legal practitioner, of course, bringing an action against that other party that didn't fulfill this obligation and cost you damages, and the court will award damages against the person. Damages can be actual, it can be specific, it can be nominal, it can be exemplary. It's general. If the court just said, okay, you have suffered the general loss, okay, it can be quantified to be this, and the court order the other person to pay that amount to you. It can be specific, where the court orders a specific amount to be paid. Then it can be exemplary, where the court, aside of granting the damages to be paid to the person that you have violated his right or you have breached, the court can also grant, the court can expect the respondent now to pay some damage as a form of punishment. Exemplary damages like a form of punishment against that person that has refused to perform his own obligation. So that can come in form of damages. So part of the remedies for breach of contract is what we call damages. And of course, we should know that it will be calculated based on what you have suffered. It will not just be, thin air. And it must be foreseeable. The damages that is foreseeable, not just from the blues. You just, from your head, I've suffered this, I've suffered. The court will put into consideration the things you've actually suffered in awarding damages against the other party. That's what we call also specific performance. It's a form of remedy against the breach of contract, where the court will order the other person to carry out that obligation, to do what he is expected to do. Of course, this is discretionary, and the courts most times, they apply caution before granting it. Specific performance is a decree by the court that directs the defendant to perform or to fulfill a legal or a contractual obligation. When the court discovers that monetary damages will be inappropriate or inadequate for the person that has suffered loss. If the court discovers that paying of these damages alone will not be adequate, it will not be enough, the court can order that defendant, that other party, carries out the obligation. And of course, once the court orders it, he must carry it out. And we should know that specific performance is an equitable relief, is discretionary. It's not something that's under compulsion. The court can decide to grant or not to grant. And if you are claiming for specific performance, you must prove to the court that you have first fulfilled your own obligations before the court will order the other person to fulfill his or her own obligation. So, and some other remedies ranging from injunction can also be part of the remedies for breach of contract. When you have breached a contractual relationship or obligation, the other person who has suffered loss can apply for damages, specific performance, for injunction. Now, another thing I want us to talk about is instances where some people would have benefited from an action and they will in turn want to claim that that contract is void. There are some contracts that can be void, but before you can say that a contract is void, you must not have benefited from that contract. You can, for example, let's say maybe money lending contract. I approached a money lender to give me a loan, and he has given me the loan. I have collected that loan and I've utilized it. Then in turn, I now come back to say this money lender does not have a money lending license, so it's the contract is void. You can't do that. You cannot have benefited from a contract or an action, then you now allege same to be null and void. That will not be good. It will be morally despicable and inequitable for such party obtaining that kind of loan to claim that it is void after you have obtained it, you have utilized it, you have benefited simply because you want to, run away from your own side of the bargain of repaying the loan and paying interest. You are saying it is null and void. The court will not allow that. That will mean that you want to be benefiting from, you want to go against something you have benefited from. It is inequitable. It is morally despicable for you to say that. We've seen cases like that where people approach you and say, okay, I loaned this person a particular amount of money, is to repay with interest. And at the long run, when it's time to pay, he's claiming you're not a money lending. You know how lawyers can be sometimes. I approach a lawyer that will come up with so many things, excuses for you to avoid the liability of paying back. No, you cannot do that. He who comes to equity must come with clean hands. So you should know that you are binded by any contract that you enter into willingly, freely, without duress, without coercion, and of course that is legal, and that you have capacity to enter into whatever it is that you enter into. You are binded by it. Now, there are instances where you enter into contract with illiterates. Sometimes some illiterates cannot understand what is in the agreement. For the fact that somebody put his thumb impression instead of signing does not make the person an illiterate. So what makes the person an illiterate is inability to understand the language you put in that contract or the terms of that contract without proper explanation or proper translation. So usually when you want to enter into a contract with an illiterate, is better and is advisable for you to approach your legal practitioner and tell the legal practitioner, that's your lawyer and your solicitor, to insert in that agreement what we call illiterate jurat. In that illiterate jurat, the lawyer will state it that he has explained to the illiterate everything in that contract before the illiterate impressed his thumb impression or before he signed. That is illiterate jurat. So you should know these vital things when entering into contract so that you not be, bringing actions against yourself. Now you should now know that once there is a breach of contract, you've entered a contract with somebody, the person has breached that contract and you have suffered loss, you have 6 years within which to bring an action against that person for breach of contract. These actions is governed by different laws. There are various limitation periods specified by statute. We have different laws of different states that notably state, their limitation laws and the respective states that it comprises of. So this limitation period generally is usually 6 years. So it's advisable if you want to bring an action against anybody for breach of contract, for you to bring it within 6 years. Once it's after 6 years, it might not be, it might have been against the limitation law. For example, anything about tort, simple contracts, bring it within 6 years. Advisable, any contract at all, bring an action against its breach within 6 years so that you will, it's better to err on the side of caution than to, think you know what you're doing. At the end of the day, you are going to be regretting not bringing it earlier. So those are just major things that you should know about contract, that you are binded by whatever it is that you enter into. Contract, like I said, is an agreement between two or more parties that states the terms, their obligations, and the consequences when they violate such obligations. For there to be a valid contract, we have said it, there are some essentials that will make it valid. There must be offer. Somebody must have offered something. There must be acceptance. The other party must have accepted what you have offered before you can say that there's a valid contract. There must be what we call capacity to enter into that contract. The person entering it must be of sound mind. The person must be 18 years and above. The person must not be a minor. The person must not, be under duress. There are so many things that will make the person lack capacity. So you must ensure that there's capacity to enter into that contract. There's also consideration. Consideration is the very essence of the contract. It is the value that each party is bringing to that contract. It could be monetary, it could be services, it could be goods, another legal tender that you agree to by yourself to be your value for that contract. It must also be legality. That contract must be legal. You cannot enter into a valid contract where what you want to be doing is illegal, something that is not known to law, something that the law has prohibited. You cannot enter into it and claim that you are doing a valid contract. It's going to be invalid. It's going to be illegal. And any illegal contract entered into is null and void and cannot be enforced. It's unenforceable. It is null, void, and non-enforceable. So you should know when you want to enter into contract, know what you are getting into, know whether it is valid or not, know whether it is legal or not. It's advisable before you commit yourself to any contract. Approach your legal practitioner. Let him go through it. Let him go through the terms and the obligation that you stated into, and know that you can fulfill it and you can go into it. Let him give you the legal advice that you need before you enter into that contract. I've talked about force majeure too. We call it act of God. Instances where another person, a party, might not be able to fulfill his obligation under a contract. If an act of God occurs now, a flood happens, it sweeps the major thing, probably building, that is the major subject matter of the contract, sweeps it away. You should know that it's not the person's fault. It's just an act of God. I made an example of COVID-19 period where we're all on lockdown in our various homes. We couldn't come out. So it will be difficult for parties to fulfill contractual obligations at those periods. So there are instances where acts of God will arise that will make your contract not to be able to be enforced or to be fulfilled. And I've talked about the remedies are available to you once the contract is breached and you have suffered loss. You can approach, the court, bring an action to court for breach of contract. Damages may be awarded, specific performance may be ordered, an injunction may be ordered, and other remedies available under the law. So, majorly what we are trying to tell you is know what the law says about contract before you enter into it. Know your own part of contractual obligations. Fulfill it because you are bounded by whatever it is that you have, willingly, freely entered into, and of which you cannot benefit from something and later claim that it is void. The court will not allow you to do that. He who comes to equity must come with clean hands. You cannot benefit from something and later now turn out to say it is invalid, it is illegal. No, you cannot do that. It is morally unjust and despicable, and of course it is inequitable to do that. So this is what we're going to be talking about. These things that we've talked about today is where we're going to be stopping, and hopefully by next week when we'll come back on this wonderful program, we bring another exciting legal topic that you need to know to help you to make informed decisions, to help you to know your rights and obligations, to make you to, help you to live a crime-free life. And until next week when we get to meet again, I pray that you have a beautiful week. The Lord be with you. Have a wonderful and rewarding week ahead of you.